This episode examines Alexander Acosta's role as U.S. Attorney for the Southern District of Florida in the 2007-2008 non-prosecution agreement related to Jeffrey Epstein. The content is based strictly on public records, including court filings, Department of Justice reports, and major investigative journalism. The discussion is presented in a neutral, factual manner suitable for general audiences. Alexander Acosta served as the U.S. Attorney for the Southern District of Florida during the federal review of allegations involving Jeffrey Epstein between 2006 and 2008. The matter began after a local law enforcement investigation in Palm Beach County was referred to federal authorities for further consideration. DOJ OPR Report 2020, Palm Beach Police Probable Cause Affidavit. According to the Department of Justice's Office of Professional Responsibility, OPR, federal investigators identified at least 34 minors during the course of the investigation. Federal prosecutors evaluated potential charges under applicable federal statutes and assessed evidentiary issues, witness considerations, and litigation risks. DOJ OPR Report 2020. In September 2007, the U.S. Attorney's Office entered into a written non-prosecution agreement with Epstein's legal team. Under this agreement, the federal government agreed not to pursue federal charges in the Southern District of Florida if Epstein resolved certain charges at the state level in Florida. 2007 Non-Prosecution Agreement, DOJ OPR Report 2020. The agreement included provisions concerning restitution and required compliance with sex offender registration laws. It also extended federal non-prosecution to certain identified individuals for conduct within the district during the relevant time period. The scope of this agreement later became a subject of public and legal scrutiny. 2007 NPA, DOJ OPR Report 2020. In 2008, Epstein pleaded guilty in Florida State Court to charges including solicitation-related offenses. He received a jail sentence and was required to register as a sex offender under Florida law. Public reporting later examined the terms of his incarceration, including work release privileges permitted under local policies. Miami Herald, DOJ OPR Report 2020. More than a decade later, the agreement became the subject of litigation under the Federal Crime Victims' Rights Act, which provides certain procedural rights to crime victims, including the right to confer with prosecutors. In February 2019, a federal district court in Florida ruled that the U.S. Attorney's Office had violated the statute by not conferring with victims before finalizing the agreement and by maintaining confidentiality about its terms prior to the state plea. John Doe 1 v. United States, SD Florida, February 21, 2019 order. In April 2021, the U.S. Court of Appeals for the 11th Circuit, sitting en banc, determined that the Crime Victims' Rights Act does not authorize victims to enforce those rights in court before federal charges are formally filed. The appellate court vacated the district court's decision on jurisdictional grounds. In Re Wild, 11th Circuit en banc, 2021. Separately, the Department of Justice's Office of Professional Responsibility conducted an internal review of how the matter was handled by the Southern District of Florida. In its 2020 report, the office concluded that Alexander Acosta exercised poor judgment in approving and structuring the non-prosecution agreement, particularly regarding its scope and confidentiality provisions. However, the review did not find that Acosta or other prosecutors committed professional misconduct under Department of Justice standards. DOJ OPR Report 2020. In 2018 and 2019, investigative reporting by the Miami Herald brought renewed public attention to the 2007 agreement and its terms. The reporting analyzed the scope of the deal, the legal strategy behind it, and the broader impact on the individuals involved. Miami Herald Perversion of Justice Series. In July 2019, federal prosecutors in the Southern District of New York filed an indictment against Epstein, alleging federal offenses involving minors between 2002 and 2005 in New York and Florida. These charges were separate from the earlier Florida state case and arose in a different federal district. SDNY Indictment 2019, paragraphs 1 to 5, 10 to 15. Following the New York indictment, Alexander Acosta, who was serving as U.S. Secretary of Labor at the time, held a public press conference on July 10, 2019. He stated, based on the circumstances and evidence available at the time, his office believed the 2007-2008 resolution secured accountability, including incarceration and registration requirements, while avoiding potential risks at trial. Acosta press conference transcript, July 10, 2019. On July 12, 2019, Acosta announced his resignation as Secretary of Labor. White House remarks, C-SPAN, July 12, 2019. Public records show that the 2007 non-prosecution agreement was broad in scope and later became the subject of legal challenges and internal review. A federal district court initially found violations of the Crime Victims' Rights Act in the handling of the agreement, and the 11th Circuit later vacated that ruling on jurisdictional grounds. The Department of Justice's internal review criticized the judgment exercised, but did not determine that professional misconduct occurred under departmental standards. 2007 NPA, John Doe 1 v. United States, 2019, In Re Wild, 2021, DOJ OPR Report, 2020. This presentation is based exclusively on publicly available documents and established reporting. Viewers are encouraged to review the cited materials for full context. For content involving living public figures and sensitive legal matters, independent legal review prior to publication is recommended to ensure compliance with applicable standards and platform policies.